So we will talk about the in-house perspective, and we'll try to offer also a comparative approach, not only in terms of how things are done in different companies, but also among different countries. Just one more second. I take advantage of this moment of calm to tell you more about my distinguished colleague here, Andrea Pisani. He has a law degree, bachelor and a master from Lewis University in Rome, which is a private university based in Rome. And then he started to work in law firm in order to do the practice, to pass the bar exam. And after that, he joined a bank in Intesa San Paolo, working in legal and compliance. After in Intesa San Paolo, he worked for investment banking, again, for a relatively short period of time, before moving to the current position in lastminute.com. So he's going to offer the point of view of an online travel agency. And as you know, probably from your own experience, when you travel, sometimes there is something going wrong. So hence the need of having a team, because he's managing a whole team of people handling the litigations. And sometimes they have litigations with customers, sometimes they have litigations with suppliers, and so they're pretty busy. And based on my experience, at least in Europe, it's not very common to have lawyers who are just working on litigation. It's very unusual. In the US, that's normal. All large multinational corporations have people who are just working as full-time litigators. In Europe, in my experience, it's much more rare. So I think that's already a kind of difference, which he's going to tell us more about. But since I'm here and talking and talking and talking, I probably need to tell you also a couple of words about myself. And it's the fact that I'm here is not pure coincidence, because in my previous life, I used to be an in-house counsel myself, and I have been doing that for a long time. I'm an Italian lawyer also, but I worked in-house in Italy for a few years. Then I started to work for DuPont, and I started to travel around the world. I spent a certain number of years with them in Italy, and then in Switzerland, and then in Belgium, and then I came back to Switzerland, where I'm still based right now. But I'm not with DuPont any longer. I left the company and set up my own practice, and I'm also teaching international business law at the American University in Geneva. So despite the fact that I was just supposed to be a moderator and to give any presentation, so I don't have any slides with me. I think somebody told me once that you are an expert when you come from out of town with slides. That means that I don't meet the definition. I don't have any slide. But I'm coming from out of town, so that's already something. Okay, I guess I told you everything I needed to tell you. I don't want to take any more of your time, so without further ado, Andrea, the floor is yours.
Thank you very much.
Doesn't work? Should I give him mine?
No, you can turn it on.
Apparently I have to press something.
Yeah, there.
Oh.
You need to press for a second or 2 seconds.
The Travis one that has a green light, so it's Hello.
Okay.
Okay. Go over.
Thank you very much, Stefano, for the introduction, and I'll try to introduce quickly myself. So, as Stefano said, I am the litigation counsel of lastminute.com group. We are an online travel agency, actually based in Switzerland as headquarters, but with business all around the world. With this presentation, I actually would like to share with you what means work as an in-house counsel, mostly for litigation matters. because in my team, I actually am in charge of litigation department, and we have offices all around the world. So the litigation is really, really transversal matters for many, many issues that we have. The first thing I would like to share is that the online travel agency is a complex sector. The travel itself is becoming very complex because, first of all, it's very dynamic, and second, we are having a lot of changes. Changes means that all providers are becoming more expensive. We have in the past 3 years more force majeure situation than profits, as you can imagine, the pandemic, the war in Ukraine, and also the excessive cost for flights that are becoming totally different from the past. So the world of travel is changing, and also all the litigation that are behind this new sector. The most interesting things about the role of an in-house litigation counsel is that, first of all, you need to understand and deal from inside. So in a complex business as mine, it's very important to firstly understand what we are going to manage. Because if I think about my, let's say, daily activity, we manage court cases from UK in the morning. We can have cases from Italy and Spain in the afternoon, and the day after we manage France, for example. So managing this means that you need to, first of all, have a lot of soft skill first, but also the approach should be totally different. In my office, for example, we have people that are in charge of legal, contracts, compliance, but the approach is totally different because when you do litigation, and mostly when it's in-house litigation, you need to have also soft skill and understand how to approach, for example, the counterpart, because mostly what I would like to share with you, in the settlement activity, anything is different if you think about a UK settlement, if you do this in Italy, or if you do this in Spain, or all around the world, actually. But what makes the job, the in-house litigation counsel, very interesting is that when you work in a company or in a group that is, let's say, with several offices, with a business that is developed in all the world, as a litigator, you need to deal every day with different jurisdiction. So sometimes, for example, when we work daily, could think that there is also a conflict when we see the applicable law for the case. And this is extremely interesting because for one side, we need to check, of course, the proceeding. We need to check what we are doing in that country, but mostly we need to deal and check what is the applicable law, because the strategy, the approach should be always the same, but you need to change strategy for each country you are managing. So this makes extremely interesting, but sometimes extremely complex. Just to give some example, if we think about what we do, we sell, for example, flights, and in this case we are just agent for airlines. It's totally different if you have a court case of a client in Europe, for example, in France, in Spain, or in Italy. Or if you have a court case in US, because the flight was served, the route was from US to Australia, for example. So in this case, the strategy is totally different. The applicable law changes, and so we need to actually have a look at exactly context of the law. So when change the jurisdiction, the most important things is, I think the interesting things is also that the applicable law is going to change immediately. Well, the most important things also in doing this job is that, you need to have a clear vision of what you are doing, because you have from one side the business, from the other side you are your liability. In a sector like the travel is very interesting how you need to, doing this job is totally different as a general legal counsel, because looking at the business, you need to have from one side, respect the budget because we have an unlimited number of cases. So what we need to understand where is our liability. And in this, we need to have some very important soft skill because to give an example, it could be very easy to have 100 lawyers per country and just send outside all the job that we receive. We receive court claims every day. We just appoint a law firm, and the law firm is able to do anything better than us, maybe internally. But our secret, and also our success of working together in the company, is that we try to have an internal guideline. We have a very well-trained paralegal team. So we have a structure that is able to see the cost, check the risk, and do as much we can internally. Why we are able to do that? Because we are working in as now all the company I think we work in an e-commerce. The technology is the first things. So we have many tools that enable us to do the job very well. So the rule is, I think, is changing year. Any year is going to change always more, because the success of this role is also to understand what the business actually wants, what the management wants, and also the reduction of the possible cost, because doing this job internally is actually extremely, from one side interesting, from the other side extremely complex. And trying to give some interesting example of what means in-house management of litigation matters. In looking at my sector, for example, we had, during the pandemic, more than 11 bankruptcy procedures for airline, in which, in this case, we were acting and working with the B2B litigation. So having this kind of in-house management helped the company to survive at the pandemic, and also to find the best solution in terms of technicism. Because if I give you some example, we had to file an admission claim internally, and the claim was done in Thailand, in Latin America, in South Africa. Everywhere the company asked for a bankruptcy procedure to allow them to continue the business. In all those cases, we could easily ask an external provider to do that, but the costs were literally unreasonable. And we successfully managed 11 procedures. And I personally went also like a witness in Thailand, for example, and I was able to recover more than 3 million. Not because I am the most expert lawyer and also able to deal with Thailand with the Thailandese court, but because doing the job for many years and be really linked to the business and to the activity, I was able to explain to the court that when we sell flights, we use a global distribution system that allow us to do the ticketing for clients. But before the client, we just act as intermediary. So we were able to explain this position, and we were able to get all the refund when we were acting as a tour operator and try to underline the airline responsibility, for example. And this was done just with a witness. So it's the new way to work, and also the best strategy to act as in-house counsel. Of course, in the daily activity that a litigation department has, we must have some external lawyer that helps such a huge department to do the daily activity. We do have external lawyers, but we do have also an incentive plan for all the lawyers that we have, that they work for us, for example. In this case, we set a number of claims that we send over to them. Of course, we need to, as per ethics and compliance, we need to respect the salary, what we must pay a lawyer, how much you need to pay a lawyer. But we always had a success fee plan that allowed the case to be very well managed. The company reduced a lot of costs, and mostly in the UK, we need to take very much attention because even a small claim can be a precedent. So we have had a lot of interesting case that we managed easily, that were maybe 100, 200 pounds, and then at the end was a case, because in the tourism and in the travel, just one case can be the most relevant of all the year. And for this reason, I think that after years and years of working as an in-house counsel, we do understand why sometimes it's much better to think that a settlement is better than going to the court. But this sometimes is interesting, because even in a situation in which you are totally right, sometimes someone asks why you are settled with the client if you are totally right. And we have a lot of cases, for example, in the UK. If you think about an injury case, when a client has an accident in the hotel, if the package was sold by a tour operator, the liability at the end is the tour operator. So the tour operator is liable before the client. And this makes the legal proceeding extremely complex and interesting, because you then need to check how you did the contract with the hotel. So if you have a direct contract with the hotel, you have a duty with the hotel to check if, for example, was totally compliant with the law. But most of the times it's also funny, because when our team went to check the case, they were, oh no, there is no accident. The client was totally drunk, they were fighting, they got a strong accident, and now they're asking more than 1,000 to you. It's not correct. But going to the court in the UK for maybe 3 years, it's a really extreme high cost and expensive. So sometimes we have learned that setting a case, mostly for countries, it's more than fighting before the court. Because even if you think of this case, it's quite complex to have evidence that allow you to be totally not liable. So for such a huge case, as everyone knows in the UK, we could have received a parallel cost proceeding, and we could have won from one side with the judge, but from the others, we have another cost proceeding, and this means lawyers, means fee. So we have also we understand very well when is the case to settle and not to go ahead with the judge. And this is quite interesting, because we need to change mind completely. If we, for example, we go to manage Spain. When we go to manage Spain, sometimes, not because the judge there are more reasonable, but because the costs are extremely lower than in other countries. So you can take risk to go, discuss the case. The lawyer that helps you, it's, of course, does not have the same cost of a lawyer in the UK or in Germany or in Switzerland. And you there are able to fight the case from the beginning to the end. So the settlement activity inside the litigation department, I really think is one of the best things to act for the company. Because, you know, everyone, it's really complex to say, okay, maybe I'm fault, but to get him away, I will find to settle the case. But it's really a balance between cost and benefits. This is actually a picture that shows what is our business, how many million passengers we have. So you can imagine how many litigation we have in the world. And our, let's say, core business of litigation is the B2C litigation. The litigation with provider is rare, because you have very good agreements with them. We don't go to the court. There could be some debt collection activity, but not really very huge litigation, except for the airline that they are doing the work to us and we actually reply. So the only case in which my company and us are like the claimant and not only the defendant are very few but big case. So the litigation that we have is really B2C, clients suing the tour operator everywhere, every time. They, of course, well, the client doesn't care if behind us there is the airline. Even if you can tell him, by terms and conditions you accept it, we are only agent, you need to go to the airline. We got millions of cases because of the 26104, for example, that is the passenger rights regulation that allow the customer to ask compensation to the airline in case of cancellation and delay. But this is expressly for the airlines. So that many times the airline is based outside of Europe, so we receive the claim on behalf of the airline without no reason. And it's extremely expensive to call in guarantee in another country, to try to defend, and sometimes even the judge is quite hard to explain them, even with terms and conditions accepted. So this makes the game really more interesting. And then ultimately, mostly for B2C litigation, what is very interesting is the ULO application versus the no ULO application. Because it's just not only where the client is based, of course, but only, for example, if we are agent, the route to check should be even just one way should be from Europe, or at least they should come back to Europe. Otherwise, we need to check to other law. So this is actually what means worldwide litigation. So we have this kind of setting, and we try to manage in this way. Well,
I'll let you finish, and then maybe
Yeah,
we
sure,
can start
sure,
a
yeah,
conversation.
yeah.
I have some questions already,
Sure,
but
sure.
I guess it's probably better if you can
Other
complete your
things,
presentation.
yeah, we have transversal litigation matter for also, of course, contracts, mostly for debt collection, as I said before. We have also intellectual property litigation. And we have, and that's also quite interesting, privacy litigation. As an online travel agency and e-travel company, and mostly e-commerce, we have and we need to manage a lot of data breach. Not because we do not respect the rules and we breach the agreement, or because we are able to not grant the privacy. Because doing this job, most of the times you need to use providers. So for example, to make the reservation, we have external providers. Sometimes the error is done by external providers. But when you receive the inspection or you have the authority coming to you, you cannot say, okay, it's my provider. You need to manage the data breach and the privacy litigation. And this is also another field that is improving, and due to, of course, in the past years, the GDPR, there is an highlight on this, and we manage very, very carefully, for example. So everything is, in a job like this, is transversal. But if I think, as then Stefano for sure can tell better than me, in many cases we can see that the litigation, the legal department is having a transformation from a cost center to a profit center, because when you do a huge debt collection and you mostly do it in-house, you are able to recover a lot of money that most of the times was lost for the company. They say, okay, this is lost. But if you try to do that with a low effort, without cost, and you are able to recover a lot of money, for a huge company, this is the litigation, the legal department is not anymore a cost center, but it's more a profit center. As for example, I remember we had an African Airlines, very, very famous, that we had to just file a claim online. And because we were careful, we asked the lawyer to do that. They asked for 55,000 and was done in one day with 3 people. So if it's just a way to prove that it's becoming really a profit center, not anymore a cost center, mostly for litigation. Good? Yeah.
Well, thank you very much, Andrea. It's a very interesting presentation. And it makes me think of at least 3 trends, which you already mentioned, but which I would like to stress a little bit more, and maybe also ask you a couple of questions in relation to that. First of all, you were talking about internalizing more work, which I guess, well, first of all, we have to remember that at least in many European countries, when you work in-house, you have to step down from the bar, so there are limits as to how much you can do in-house. But it is always possible to bring more work in-house, which not only is reducing the cost of a company, but it's probably making your work more effective, because as an in-house lawyer, you're closer to the business needs and you understand better what should be done. So I guess that's an important trend I wanted to mention again. And the other one, which I heard as well, is the need to try to bring these cases to a conclusion as early as possible. I remember when I was working in-house, the major need of business customers was, when are you going to finish this case? When are you going to reach a settlement? Because I guess the approach is to get rid of these cases as quickly as possible. And a decent settlement is always better than, you know, a good decision or a full win, but 3 years down the road. So my question to you is, to what extent, in order to come to these early conclusions, to these early settlements, do you use in general ADR, alternative dispute resolution mechanisms, like mediation or even arbitration, because I heard you mainly go into court, and to what extent you find them useful in your practice?
Well, we have tried many times, and I unfortunately need to say that was not very helpful in terms of timing. Because the process was too long, and then also because for my structure, we have, for example, a seller company based in Switzerland, and most of ADR was not done because it was not possible, because the company, the counterpart company, was based in Switzerland. But when we had tried mostly in France, for example, I remember, or in Spain, I can say that was an alternative way to settle, but it's much better to do internally with our ways, because if I think in Spain or in France, what we could see was that always in favor of the client. So just to say, close and settle, because the customer is always right. This is my experience with the ADR, but I am happy to change my mind and try again.
Yeah, it is certainly true. There is a difference between B2C and B2B, because in B2B, I guess the relations are more balanced. In B2C, as you said, probably there is a tendency to favor the weak part,
Yes.
which is the consumer, obviously. Another trend I spotted in your presentation is when you were talking about the transformation of a legal department from a cost center into a profit center. And in that respect, I have to say that we had a long experience when I was in DuPont. DuPont was probably among the first, if not the first, to introduce a so-called recovery plan. A recovery plan means that you actively pursue all potential claims. You don't let them go down the drain, and in order to recover the maximum amount of money for the corporation. That recovery plan was so successful that over a period of a bit more than 15 years, it brought back to the company something like $2 billion, so just to give you an idea. I know that in today's environment, more and more companies have active recovery plans, and I also heard from you that you, to the extent possible, you try to do the same. So do you also agree that you know, this more active approach taken by the legal department can really help to generate more revenues for the corporations and therefore be beneficial for business in general?
Yes, absolutely, yes. From my experience, I can really say that it's one of the best things that we are doing, and I think that in the future will go even better. So we hope so. We hope that everyone will understand this, but managing cases and can help really to see how you are able to get profits. Mostly for debt collection in our case, because for the B2C, the B2B side, recovering amounts with really small effort and no cost is quite an example and a proof of this.
And do you also have cases like, contractual breach or, tort cases? Not tort cases, not so much.
No.
Contractual breach, I guess you can
Yeah,
still
yeah,
have
yeah,
with
yeah.
your partners and
Yes, yes.
maybe suppliers more frequently than others, or?
Yeah. We do. We are also lucky that we have few relationships with very good provider because we work with bed bank strategy. So we have big four providers reservation. So we cannot, it's very rare that we have a breach of contract with them. With a small one, for sure. And even there, yes, the experience is applicable and the case is to have profit and not to have a cost for the company.
Do we have any question or comment from the audience?
I have a loud voice. I think I can do without mic. Do you have any threshold below which you don't do anything? So just let it go?
Oh yeah, sure. It's interesting, but this is per country. For example, in Italy, we do not even check, honestly, court cases behind 2000 because they are managed by giudice di pace, that is like not a very expert judge, and sometimes if you spend time into the witness statement, into the defense, you need to wait maybe 3 years, and the result is absolutely very far from law. That's super important because I cannot apply this rule, for example, neither in Germany, neither in UK, where, for example, if I really lost a case because I didn't check the mail and I receive a court claim of 2000 and I don't check and I don't defend it in 40 days, I will have a bailiff come to the office and remove goods immediately. So there are jurisdiction, that's why I told you before, it's quite complex because it's different. I really need to check every single cases in Germany and the UK, even if when there are no reason to receive this claim, the counterpart is not correct. We receive cases even when we do not have a reservation, but I need to check and defend the case, otherwise, after 14 days, it's immediately in default and can be enforced by the claim, and I don't have any chance to defend it. So it's really coming to your office and to remove the goods. So we do that, but not for all the countries.
May I ask another question?
Sure.
Do you buy your legal services in the different countries bulk? Like, say, 10 default cases in France and 10 in Germany? Or do you pay the law firms case by case? Because every year
Yeah.
you will have so many cases. You can do the statistics. And you know that in the US you have X per year.
Yeah.
Do you use one firm, or do you use many firms? Do you
We
alternate
use-
with firms?
We use one firm per country, with the only exception, we have like an agreement that, for example, we are going to pass you 20 cases per month, for example, and we have a fixed rate basis. But this is for each country because the cases are a lot. When we need to defend to go to the court, we cannot personally go every day to the court because I can't, but I don't have neither the time to do that. But we just need to have a different firms when it's about UK injuries and food poisoning case, because it's quite interesting. There is a field totally different, things that I don't see in Italy or in Spain or in France, for example. And when the case, the small claim is related to a practice, we have a competition firm that helps us because most of the times we have authority coming and ask more questions. So we have our agreements with all around the world with the law firms, but when for UK and when it's about an unfair practice, we immediately need an assistance of another law firm.
If I can add a comment on that, there is always this debate if it is better to have a close partnership with one firm or organize beauty contest whenever it makes sense. This can be an eternal discussion. What I have experienced, especially for, let's say, regular matters, having a law firm with whom you have a close understanding and which can hit the ground running, and because they know the culture, they know the company, they know the people, and they know what type of disputes you're going to have, it's normally better than shopping around. Shopping around makes maybe sense when you have a big, extraordinary transaction like an M&A or an acquisition or a huge joint venture or whatever. But for regular matters, in my experience, it's always preferred to have a close partnership with individual firms, country by country, because they can cooperate much more effectively and much more rapidly. I think we have another question
Yes,
there.
the question is, for example, now in Saudi, if the government aside in the contract, we don't have, for locally, I mean the local contract between two Saudis and the government is a party of this contract. We don't allow us to go to the settlement, you have to go to the court. But if the government sign an international contract, yes, we can go to the settlement. So as your experience, if you, for example, a lawyer of the side who is gonna go into the contract with the government, so what you gonna advise them?
Well, I mean, as far as I know, there is not this restriction in Europe. I don't want to be wrong, actually. But when there is a public company also involved in any case of litigation, the settlement should be done carefully, and also because we must check different rules that are not only the litigation one. We need to check the competition. We need to check if, for example, I remember a case that the county, the government was asking also public damages. So it's not easy to settle, because you can have the risk that you settle with one side and then the government can take any other action from the other side.
But internationally, but if you are in the local, the government doesn't allow you to do a settlement if that's the contract is, Saudi contract is locally. So now you are a lawyer and you know if that's a dispute happen, you don't have a settlement side, you have to go to the court. So what is the risk mitigation for the contract before when you get involved with the government side?
Well, I don't know if I can step in this discussion. I guess, as far as I know, in many countries, the governments can reach settlement agreements.
Internationally.
Now you maybe have a specific restriction in Saudi, of which I'm not terribly aware. What I have experienced is the difficulty to even when they can, is the difficulty to convince government representatives to make settlements, because they're always afraid of somebody accusing them of having made concessions which are too generous, accusing them of corruption, accusing them of having done something which was not for the benefit of our country, and so far and so forth. So the risk is that it's very difficult to make a settlement agreement with government representatives because of these fears. Just for your information, in case you don't know, I mean, you know that there is this reform of investor-state disputes going on at Amsterdam. One of the proposals they are making is to try to promote mediation in this type of investor-state disputes, because they are very well aware of the fact that it's extremely difficult to make a settlement. It will be beneficial for everybody, including the government, but nobody has the courage to do it. So my impression is it's difficult to overcome these obstacles. Hopefully it will be possible to introduce new mechanisms which will make it easier in the future, and to take advantage of the possibility to have negotiated settlements also with government officials. If we don't have, we have another comment there.
We don't.
That was the problem I had in Italy, you know.
Yeah.
You cannot defend in court, and if you don't have the legal privilege, there's a problem when you have a proceeding promoted by the authorities, if you do internal investigation or something like that. You don't have it, no. Okay.
And that's one more reason to involve an outside counsel, of course. Any other question? If not, I guess maybe we can try to draw some conclusions here. I guess what we have observed is Sorry? I know. What we have observed is a more active role of legal departments in managing litigation, further internalization of a process to the extent possible, and this need to try to finalize the disputes as quickly as possible, because, as you certainly know, the business is interested in reaching, as I say in American, the top line, which is the sales, and the bottom line, which are the profits. And very often, litigations are seen as a distraction. However, there are cases where litigations can be transformed in a kind of revenue-generating activity, and in that case, it becomes much more easy to get the attention of the business people with whom, as an in-house, you're normally working day after day. Anyhow, if we don't have any other comment, I think we can close it here. We have respected the time. We are 2 minutes earlier. So thank you very much for your attention.
Thank you very
very
much.
much, Andrea.